In this race, Judge Tyson's name appears first on the ballot, and if you want to stump the judges during the break, ask them how the order on the ballot is determined. It is crazy. Judge Tyson.
Good morning, and thank you for this opportunity to speak to you today. My name is John Tyson. I currently serve as one of your judges on the Court of Appeals. I am seeking re-election to my seat. I'm going to rely on my background in the resource profile, but I wanted to bullet point some of the experience. I was first elected to the court and joined it in 2001. Since that time, I have ruled over 6,000 appeals and have 2,000 opinions. My record before the Supreme Court is 98% of my opinions have either been affirmed or left undisturbed. I have extensive civil practice. I practiced for 7 years. I have served on numerous administrative boards, Soil and Water, Planning Board. I chaired the State Ethics Commission. I served on the Property Tax Commission, and I currently am vice chair of the Dispute Resolution Commission. So that is an extensive civil and administrative practice, which I understand is important to this group. I'd ask for your continued support. I thank you for the support that you have given me in the past, and I would welcome and ask for your vote in November. Thank you.
Good morning. First of all, I want to thank you all for this opportunity to be here. This is my first time, but I'm grateful for the audience. Thank you all so much. Raised in the tobacco fields of Warren County by a single mother of 4, I learned at an early age the importance of hard work. I watched my mother struggle to provide for her 4 children while instilling in us the importance of having faith, staying focused, and finishing what you start. I graduated from UNC Chapel Hill and from North Carolina Central University School of Law before joining the United States Navy as a JAG officer. After I proudly served my country, I worked as an assistant district attorney and as an assistant federal public defender. In 2012, the people of Cumberland County elected me to serve as a Superior Court judge. As a Superior Court judge, I understand that my decisions affect the lives of everyday people. I also believe that individuals who appear before me should be treated with dignity and respect. I understand what it's like being in a courtroom and having a judge on your back when you're simply trying to manage your client, trying to make sure you have the foundation that you need to get a piece of evidence in. I understand all the pressures that pull at you, and so the last thing you need is a judge riding you through the entire trial. I understand that. I get that. I was a litigator for many years. I also understand how important it is to be prepared. Civil is not my background, but as a Superior Court judge, I go in sometimes the week before I have court to read through files and to review motions and memorandums of law to make sure that I am prepared when I come into court on that Monday morning, so that when you all are arguing, I have some frame of reference and I'm not just coming at it cold. I also understand that people are counting on me to decide cases that are not based on politics. Thank you.
Both of you are experienced judges. As defense attorneys, we have a concern about juries receiving evidence that is not admissible. Please describe your philosophy on the role of a trial judge as the gatekeeper on admissibility of evidence. By way of example, you may discuss Rule 702 of the Rules of Evidence and the admissibility of expert testimony. Judge Tyson.
Well, we've had numerous cases to review trial court decisions under Daubert, under GE, under Joyner. All of those decisions from our U.S. Supreme Court determine the gatekeeper role that a judge has in admitting expert testimony. It must be based on peer-reviewed sound science, and it has allowed trial judges to control what is really testimony on pseudoscience or science that does not have any basis. We review admissions of evidence on the appellate court under an abuse of discretion standard. That is a deferential standard to the trial court. However, when we're looking at expert witness testimony, we must apply the provisions and the factors that are in Daubert, Joyner, and GE. So in terms of, we all know under the rules that the evidence must be relevant. It must not under 404B. So when we look at non-expert witness, the standard on appeal is deferential to the trial court, and that is whether or not the trial judge abused their discretion in admitting that evidence. Thank you.
Thank you. Judge Adams.
So unfortunately, very often, the expert testimony that is coming before us, we have no frame of reference. We don't know, certain matters about that particular specialty. But this is where you all come in. You all help us make the right decision as the gatekeepers. If you all are prepared and you're arguing your positions and you've come in and you've researched it, help us make the right decision. That's what I would ask of you. Make sure that you've researched it, understand that there's a foundation that has to be laid, and everything that you need to, like I said, make sure that you give us the tools in order to make the right decision as the gatekeepers. So we're counting on you. Of course, we're going to read and research. That's what I do anyway. No matter what you give me, I'm going back and I'm researching it for myself so that I know once this issue is before me. Like I said, we want to make the right decision, so I'm researching and trying to get it right so that when it gets to the Court of Appeals, I've made the right decision. But like I said, we're counting on you to help us with that, because oftentimes we don't necessarily know. You all know your cases so much better than we do. So you all can help us with the gatekeeper role that we have.
Thank you both.
Thank you.